Okay.
We were here a couple weeks ago on Mr. Byerly. It's my understanding I had previously prepared for a hearing on those new offenses. At that time, the case was reset, so I did not have the officer subpoenaed for today. I can certainly get them if the court would like to hear from those. It's my understanding that he now intends to enter pleas of true to those new offenses. When we were here last, we had semi-made the suggestion of ISF/SafeP. It came to my understanding that he's already gone to ISF, just from the reaction that the court kind of gave us to that, and in my extensive conversation with Ms. Johnson, we have taken that offer off the table and made an offer of 5 years in all.
Welcome to Judge Point. Before we dive into today's gripping courtroom story, make sure to subscribe, like, and share this video to stay updated with our daily uploads. In this case, we follow the proceedings of Mr. Blay, a man facing multiple felony charges. What begins as a procedural hearing quickly turns into a tense back and forth over probation violations, substance possession, and new offenses. As the judge works through each count, the weight of the law becomes undeniable. Let's unravel this dramatic hearing and witness how justice unfolds, step by step.
I only see 2. Is there another set of paperwork? I've got the 2 MTRPs. I don't see the new case. So, we already went through those motions. I guess I just need to go through them again because there's going to be a change of plea. Let me, if you'll print the second one, I'll print the first one. Let me get those pulled up real quick just to make it easier for me to go through. And
the hearing opens with the prosecutor addressing the judge. A few weeks earlier, the case had been reset, leaving officers unsummoned. Now, with the defendant intending to plead true to the new charges, the state withdraws its previous offer. Initially, a placement in ISF was discussed, but that option was taken off the table. Instead, prosecutors bring a tougher deal: 5 years in prison across 3 felony cases. This sets the tone. No more leniency, no more alternatives. The stakes have escalated sharply, and the courtroom air grows heavier.
I'm going to just rescind everything that we did at the previous hearing, and that way we start fresh from this hearing, and there's no mistake on what everyone's agreement is and what he's pleading true to, and we'll do all of that today. So will he waive the formal reading of the motion and the indictment?
He will.
The motions. Okay. Mr. Byerly, in cause number 18-28800, I have a first amended motion to revoke your unadjudicated probation. It shows that you were placed on probation May 13th of 2019 for the offense of violation of a protective order. That's a 3rd-degree felony, and that was a 10-year deferred probation. Is that correct?
Judge turns to Mr. Burbank, defense counsel, for confirmation. He agrees to the state's new offer, but an issue arises. Some paperwork is missing. The court carefully reviews motions, indictments, and modified documents to ensure accuracy. Every signature, every count must be double-checked. For Mr. Blay, each page carries the weight of his future. The judge insists on starting fresh, resentencing everything from this point forward to avoid mistakes. It's a meticulous process, but one that ensures transparency. Every word spoken in this courtroom seals Mr. Blay's fate.
Also for violation of a protective order, a 3rd-degree felony, and that was also a 10-year deferred probation. Is that also correct? And so it alleges that you violated your probation, and y'all are going to go
1, 2, 3, 4, and 6.
Okay. The new offense that he's about to plead is the possession, right?
Correct, that should be number 6.
That's 5. 6 is that he possessed it. I mean, but 5 is committed the offense. So that would make sense.
I'm sorry, they're different numbers at each one.
Oh,
One is 6
great.
and one is 5.
I love that one.
Now the judge addresses Mr. Blay directly. His probation history is laid out in detail. In 2019, he received 2 10-year deferred probations for violating protective orders, serious 3rd-degree felonies. But since then, he has repeatedly violated terms. The courtroom falls quiet as the judge lists each alleged violation. This moment is crucial. Will Mr. Blay admit the truth? Under oath, he is asked count by count: assault, positive drug tests, failure to attend required programs, alcohol use. The judge demands a clear answer. True or not true?
Count one in each of these cases alleges that you violated your probation by committing the offense of assault April 21st of 2025. And is that true or not true?
True.
And then count two alleges that you provided a urine sample April 29th of 2025 that tested positive for opiates in each case. Is that true or not true?
True.
Two. And then count three alleges that you failed to provide verification of attending the JCDI program. Is that true or not true?
True.
And that's in each case as well.
One by one, Mr. Blay responds, true. His admissions stack up like heavy stones. Assault in April, a failed urine test later that month. Missing his court-ordered program. Drinking alcohol against probation rules. Each violation is confirmed without hesitation. The final and most serious, possession of a controlled substance in May 2025, also earns a true. It's a sobering confession. His repeated failures to comply with probation terms are undeniable. The judge carefully confirms his answers, leaving no room for doubt. Each plea carries him closer to prison time.
1828800 alleges that you committed the new offense of possession of a controlled substance May 29th of 2025. Is that true or not true?
True.
Is that enough for everybody?
Yes, Judge.
Sorry. I feel like I've gotten through it without messing up, but if I keep going on the different numbers. All right. Did you enter your pleas of true in each of those cases freely and voluntarily?
Yes, ma'am.
And because those counts are actually true?
Yes, ma'am.
In both of those cases, I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1.
The judge now examines whether Mr. Blay's pleas were voluntary. Did he fully understand his rights? Was he coerced? After verifying his signed documents with his attorney, the court finds him competent and clear-minded. Evidence is entered into the record. With that, the judge rules the pleas as freely and voluntarily made. This is a turning point. The state now has everything it needs. By admitting guilt, Mr. Blay effectively closes the door on trial. Instead, he walks directly towards sentencing and the punishment that follows.
In each of those motion to revoke your unadjudicated probation cases, I am going to find that you entered your pleas of true freely and voluntarily. And cause number 1829063, find counts 1, 2, 3, 4, and 5 true, find sufficient evidence to find you guilty, and at this time find you guilty of violation of a protective order, sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 1828800.
Sentencing begins. In the first probation case, the judge finds all 5 counts true, revokes his deferred probation, and imposes 5 years in the Texas Department of Corrections. In the second case, counts 1 through 6 are confirmed, bringing another 5-year sentence. But instead of stacking, the sentences will run concurrently, together. For Mr. Blay, this is a small relief. Still, the message is clear. Probation is no longer an option. What was once a chance to rebuild is now replaced with years behind prison walls.
Okay. Now, Mr. Byerly, in cause number 25 DCCR 0943, you're charged by indictment with a third-degree felony offense of possession of a controlled substance from May 29th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? In that case, I also have here on the computer some documents that have your signature on them. Did you go over these also with Mr. Burbank?
Yes, ma'am.
And do you fully understand them? And you understand if I follow this agreement, you will also be waiving or giving up any right to appeal.
Yes.
Also, do you understand if you're not a U.S. citizen?
Finally, the judge addresses the new indictment, possession of a controlled substance. Mr. Blay pleads guilty, once again confirming it is voluntary. The court explains the consequences, not only prison time, but also the loss of firearm rights and potential immigration effects. With his attorney at his side, he acknowledges everything. The sentence, another 5 years. Like the others, it will run concurrently. 3 cases, 3 guilty findings, all merged into one 5-year prison term. The courtroom reaches its conclusion. justice delivered with solemn authority.
The trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank. All right, good luck to you, sir. Thank y'all. Thanks for your patience for me getting through that.
Sentencing complete, the judge reminds Mr. Blay of his firearm restrictions and his waived right to appeal. For him, the legal battle ends here, 5 years in prison, the outcome of repeated violations. For us, it's a glimpse into how the justice system handles repeat offenders and enforces accountability. Thank you for watching Judge Point. If you found this case insightful, make sure to like this video, subscribe to the channel, and hit the bell icon so you never miss an update. Stay tuned. More courtroom stories are coming soon.